Officially welcome to everyone to this session of 76 Connects, which I think should be a very lively discussion about a potentially kind of transformative time in our own lives and in our history. I'm grateful to all of you, especially to our guest. I'll say a word about Lawrence Douglas in a moment, for taking the time to join this conversation tonight and to strengthen the connections, which is what our aim is in this 76 Connects program. So many thanks to all for continuing to join us. Thanks to the planning committee, especially to Wendy Mantell, who's busy working there with the headphones on, for all of her assistance in planning this session. And then let's turn to the topic: the U.S. Constitution, the presidential election, and a divided nation. And just as a way of quick introduction, I just want to say that there are, I believe, lots of imperfections and ambiguities and contradictions and paradoxes in much of our history and in the Constitution, which are arguably are reflected in how we are experiencing democracy today, historically and today in more contemporary terms. Just a couple of things that I read that I found interesting from the Times right after the election. But probably, well, two things. One was by, I think he's a psychologist named Gary Greenberg. He said, perhaps it's an opportunity to, quote, join together to protect the beautiful uncertainties of democracy. I think that's something I and many of us learned in American studies at Amherst. Another one is from the presidential historian John Meacham, who wrote, America has always been shaped by the tension between hope and fear, justice and injustice, grace and rage. Whether the good prevails over the bad, whether we move closer to the promises of the Declaration or farther away from them, is contingent on the habits of heart and mind of a sufficient number of Americans in power and far from it. Piece written by John Meacham. So today's focus is on the U.S. Constitution, its ambiguities, its beauties, its imperfections, evident not only in the election itself, but I think in many of the post-election questions we're facing today: separation of powers, advise and consent, and concerning appointment of the cabinet members. So, will the Constitution and the institutions of our civil society protect democracy or challenge, maybe even upend it? So, to help us make sense of all this today, we're joined by Professor Lawrence Douglas, the James Grosfeld Professor of Law, Jurisprudence and Social Thought at Amherst. Lawrence is a legal scholar. He has authored journalism, fiction, and nonfiction, published, I think, 7 scholarly books and a couple of novels. His most recent book, Will He Go? Trump and the Looming Election Meltdown, predicted Trump's efforts to remain in office after the 2020 election. Lawrence received his BA from Brown, MA from Columbia, JD from Yale, and I think currently teaching legal institutions and democratic practice. I think that's one of his current courses, which is relevant to what we're doing. A quick word on format. We'll turn it over to Lawrence for 30 minutes or so to share his perspectives and to leave us with some questions to think about in our breakout rooms. After his talk, we'll then automatically, correct, Wendy, be moved into breakout rooms. So after Lawrence speaks, we'll go to your breakout rooms for about another 30 minutes. And as a reminder, we don't have formal facilitators. I believe Lawrence may give us some questions to think about. And just as a reminder, in those breakout sessions, it's an opportunity for everybody to talk. Please, listen, be respectful. Things we've done before, I think. Allow time for each other to share their perspectives. After the 30 minutes, as Wendy said, we'll then come back to wrap things up for some final comments and questions to Lawrence. So thanks again, everybody. We may have people, joining here and there. And again, as a quick reminder, if you're coming in under my name, just simply go to the 3 dots at the top of your picture and change that to your name. Okay. And thanks, Lawrence Douglas. We'll turn it over to you. Thank you for joining us.
Absolute pleasure. One thing I would urge is what I always say to my students back in the day of COVID. Those of you who haven't turned on your camera, I think it would be great if you were able to turn on your camera, so it makes for a more participatory experience. So if you're able to do that, please do activate your cameras. The other thing I would say is I'll be talking about the Constitution, and I'll be looking in the corner of my eye at what Paul Smith has this, how he responds. Since I remember once teaching a course where I had this one student who had a freakishly detailed knowledge about the subject that I was teaching. And anytime that I was saying something, I would sort of kind of glance in his direction. And every now and then he'd be going like, and I'd say, but let me get back to you all about that one. And so that's what I'll be doing with Paul as well. I'll be kind of glancing in his direction to see how he responds. We're going to be talking about the Constitution today. And I think the point of departure is going to be a somewhat surprising statement that Ruth Bader Ginsburg uttered towards the end of her life. And she said the following. She said, if I were advising someone on how to write a Constitution today, I would not, that is, repeat, I would not refer them to the US Constitution. She thought the Constitution had certain, for all its greatness, certain defects, which to her mind made it less than a peculiarly adequate template for contemporary constitutional building. And I want to kind of focus on those things. I think probably some of you are familiar with the general rubrics of the Constitution, maybe not, but I want to at least focus on some of the things that I think we probably wouldn't want to write into a Constitution if we had the opportunity to redraft the Constitution today. Can you see it now?
There we go.
Yes?
Yes. Now we got it.
Yeah.
And it should say Constitution of the United States. Yes. Excellent. So, as we all know, the Constitution was drafted in a steamy hall in Philadelphia in 1787. And here you can kind of accuse me of being the woke, politically correct professor at Amherst College when I observed that it was the product of 55 persons who participated in that constitutional convention. Though if I said 55 persons, that of course is a little misleading in terms of the gender ambiguity, because anyone want to shout out what you might think of the gender breakdown of those 55?
All men.
All men. Okay.
Men.
Let's push a little further. Anyone want to take guesses about the race of those 55 men?
All
white.
All
All white. And let's take one step further. What about the religion?
Oh, all Christian.
Protestant. Obviously all Christian, but that's even way too generous, way too general an understanding. What Christian denomination are we talking about?
Protestant.
Protestant. Well, actually, a little overstatement. There were 2 token Catholics there. So there were 53 white Protestant men. Here's an interesting one as well. What was the average age of the framers of the Constitution, these founding fathers? You think, whenever you use the word father, I think you would think of people of a certain age, a certain gravitas. Yeah. And
39.
It was actually 36. And the average age was 36. And so if you think about it, these were people who were just old enough to become elected president of the United States by the terms of the very Constitution that they were drafting. And that age of 36 was also somewhat inflated by the presence of one framer who was quite elderly. Anyone want to take a guess who that framer was?
Benjamin Franklin.
Benjamin Franklin, exactly. So Benjamin Franklin actually bumped up the age by a couple of years. So that if you take Benjamin Franklin out of the equation, The average age was about 33 of the people who participated in the framing of the Constitution. This, of course, is the preamble. The preamble, one of the things it says right at the outset is to form a more perfect union. And one of the things that we might say is more perfect than what? What's it more perfect than? And again, I don't want Paul Smith to be answering all the questions, so anyone can shout it out if you want. So what do you think they mean by more perfect than what?
Articles of
Confederation.
Confederation.
Exactly, Articles of Confederation. So this was not the first experiment in constitutional writing. We already had a constitution. The Constitution was basically in place from 1781 to 1789. That is until this new document was ratified. And it had obvious defects. And again, these defects are probably familiar to some of you. Some of the defects with the Articles of Confederation, it was really a kind of a loose assembly of states. You can almost analogize the Articles of Confederation to the European Union today. In many ways, the European Union, you might say, is even kind of a stronger confederation than the Articles of Confederation. The Articles of Confederation, you could ask yourself, I'd like to ask students during the tenure of the Articles of Confederation, 1781 to 1789, who was the president of the United States? Little trick question, folks, because of course there was no president of the United States during that period, because one of the defects in the Articles of Confederation is there was no executive branch. So there was no executive branch. So in terms of the legislative branch, unicameral, so just a single, wow, who just scribbled on the screen here?
You did.
I did, okay, that's interesting. Okay, all these fun little things that one can do.
That's Benjamin Franklin.
Yes, so it was unicameral, so it was just one body of Congress. Each state had, there was different representation depending on the size of the state, but each state had a single vote in Congress. And there was no power to tax. There was no power to tax. So basically, the Articles of Confederation, the federal government was responsible for basically relying on the voluntary contributions of states to keep the federal coffers, to keep the federal government running. And another key, which is kind of interesting, is to amend the Constitution, you needed unanimity from the states. So all the states need to agree to an amendment in order for you to amend the Articles of Confederation. The defects in the document became really clear very quickly. And so Congress in 1787 authorized a new convention, and the convention actually was not to draft a new constitution. The convention actually was to draft amendments to the Articles of Confederation. And what ended up happening in 1787 is we can describe this kind of as a rogue convention. In terms of the structure, now this is again is unbelievably annoying since I should be able to scroll down. And why I
got the pen on. Got the pen on. That's
yes, I'm going to take the pen off, and some people, whoever alerted me about the pen should know that. So we have our older son is a design engineer at Apple, and he describes my computer literacy as, he says he is embarrassed to have a father with computer literacy that I demonstrate. Share that with you all. Article 1 of the Constitution, probably some of you recall, Article 1, legislative branch, Article 2, executive branch, Article 3, judiciary. I actually want to focus on a couple of things in the about Article 1 that that a lot of people might not pay a whole lot of attention to. First of all, we're told that the representation, we sort of know that, is apportioned among the several states. according to their respective numbers. We know that we have this 3/5 compromise. Does everyone remember that from your either college or high school civics? You know, that was this unfortunate compromise in which slaves were treated as 3/5 of persons. As a result of that, that really ended up, if you think about it, inflating the congressional representation of Southern states. So, for example, in 1790, Massachusetts, the Massachusetts voting population was substantially larger than Virginia's voting population, that is, of eligible white voters. And yet Virginia had 5 more representatives than Massachusetts. And why was that? That's because Virginia benefited from this 3/5 compromise. But I actually want to focus a little bit further down on this. The actual enumeration, that is, of the numbers of people in the United States, is done within 3 years of the first meeting and within every subsequent term, 10 years. So we now know that the census actually has an anchor in the Constitution itself. And here's the interesting one. The number of representatives shall not exceed 1 for every 30,000. The number of representatives shall not exceed 1 for every 30,000. Now, to ask, just to make sure that we're all rowing in the same boat about this language, so could you have 2 representatives for 30,000? Yes or no?
Oh.
You have 50-50 shot, as I say to my students on this one.
Representatives.
Could you have 2 representatives for every 30,000?
No.
No, clearly not.
No.
Let's say we had, this was basically at the time the Constitution is drafted and then ratified a couple of years later, basically you had 1 representative for every 30,000. We're, in a sense, we're doing what I would describe as a humanities exercise. So I'm not going to pretend that we're all have advanced degrees in math, but let's ask ourselves, what if we had 1 representative for every 30,000 people today, like we had at that time? So the population of the United States is about 340 million. 30,000 goes into 340 million. Anyone want to do the math in their head?
About 1,100.
100,000?
Who said 1,100?
1,100.
Okay. Let's think about that one more time. 30,000 into
10,000.
What?
Yeah.
11,000 times.
11,000.
We would have, if we had the same intensity of representation that the original republic had, we would have 11,000 members in the House of Representatives. So instead of meeting in Congress, you would meet, I don't know, I guess in Madison Square Garden or someplace like that. But it is very interesting to think about, just to pause and think, what does that do to a democracy in which the intensity of representation cannot exceed 1 for every 30,000, but it can be very dramatically diluted on the order of, what are we talking about? 30 into, so basically right now, let's do the math. We have 435 representatives in Congress, in the House of Representatives, and 435 goes into 340 million. About how many times?
800,000.
800,000. And so that's a very dramatic dilution in representation. And it's interesting to bear in mind that the United States, with the exception of India, which of course has a far, far larger population than the United States, we have the most diluted body of representatives of any Western democracy. So if you just looked at a comparative basis, Germany basically has 1 representative for every 130,000. France has 1 representative for every 120,000. England has 1 representative for every 100,000. Canada, 1 representative for every 110,000. So the United States basically has over history, we've seen a very dramatic dilution in representation. How did that happen? Well, it largely happened as a result of a law that was passed in 1929. And this law was called the Reapportionment Act of 1929. And basically, the House of Representatives increased in size every 10 years with the new census through 1910. And then in 1920, for the very first time, the House of Representatives did not increase its size. And so we have had 435 as the number of representatives in the House since basically since the 1910 census, although the population of the United States has over tripled in that time. And if you want to know, you might ask yourself, well, why? Why did they freeze the number? Why did we pass this 1929 Reapportionment Act, which basically said we're no longer going to increase the House of Representatives? And instead, what we're going to do is every 10 years with the new census, we're playing this zero-sum game. So if one state gets more representatives, another one has to lose. Does anyone want to take any wild guesses as to why they decided to do that?
You have to build a bigger building?
Yes. Yes, exactly. It's because it would be like, to almost go back to that famous line from Jaws where we're going to need a bigger boat. The idea is like, we're going to need a bigger building. It was really that kind of the size constraints of the House of Representatives itself that fueled a decision which you can ask yourself whether that's really a healthy decision for our democracy. So just something to think about. Here's another one, which the Senate of the United States, as we all know, shall be composed of 2 senators from each state. Now, I am willing to be the focus of all sorts of attacks from you all, but I would say that if we were redesigning a constitution, I would say, again, first things I would say is we'd probably make the House of Representatives a good deal larger than we have it now. We probably want to have increased representation than what we have it now. Say if we were drafting a new constitution, I don't know if we would have a Senate like this at all. The way in which the Senate gives this disproportionate power to small states. Now, obviously, states' rights were a very important thing at the time of the early founding. And I don't mean to trivialize the importance of state rights today, but I do think that the present composition of the Senate creates a system more of minority rule rather than majority rule. So let's just look at something like some obvious things. So at the time of the framing of the Constitution, the largest state's population was about 9 times larger than the smallest state's population. So again, was there a disproportion? Absolutely. But if you look at the ratio in population between, let's say, Wyoming and California today, there you find something along the lines of, well, how many people in California? About 40 million. How many in Wyoming? About 600,000. 600,000 goes into 40 million. How many times?
60? Wait.
A little more than that. Yeah, but we're talking like on the order
60,000 plus. Yeah.
Yeah, exactly. Almost 70 times or so. So again, that's and so you can think about it this way. Every senator in California represents 20 million people. Every senator in Wyoming represents 300,000 people. And you want to ask yourself, what is the constitutional justification for a regime like that? And it's very hard to come up with that. Even if you look, for example, at the present composition of the Senate, we know that as a result of the 2024 election, the GOP has now captured the Senate. But right now we have a 50-50 split in the Senate, 50 Democrats, 50 Republicans. But if you look at the number of people that the Democrats elected to the Senate represent. They represent close to 50 million more Americans than the Republicans. And again, I think we can discuss this. It might be a good opportunity, good thing for us to think about, but we can ask ourselves, again, what is the constitutional justification for that type of arrangement? I'm not sure that we would want to have one. I'm going to go down to another thing. This again is a part of the Constitution that we might want to wish that we had some more clarity about. And now I'm going to jump all the way down to Article 2, which establishes the executive branch. Oops, we already went way past Article 2. Where did we? Oops. It's so short. It's so short. It's easy to skip over. Okay, I'm going to do a little. Unfortunately, it would be a little easier to do this if we were all together. But I want us to. We're going to do a little comparing of texts here. The executive branch shall be vested in a president of the United States of America. Everyone see this language? Executive branch shall be vested in president of the United States of America. And I'm going to scroll right back up to Article 1. All legislative power herein granted shall be vested in a Congress of the United States. All legislative powers herein granted shall be vested in a Congress of the United States. Whoop. Skip really quickly back down to the executive power shall be vested in a president of the United States, America. Shall be vested. Go right back up here. All legislative power herein granted shall be vested in a Congress of the United States. Anyone see any difference in the language? Did anyone notice any? Again, it's a little hard to do when we're just kind of scrolling quickly back and forth. But anyone notice anything that's kind of a little difference in the language?
Herein granted.
Yes, exactly. Was that Rob Cushman who said that? Yeah. And what do you make of that, Rob? Why do you think that language might be of importance to it? So I'm gonna again try to annotate this, and then that will then mean that some disaster will happen.
Well, to my mind, that modifier of herein granted would suggest that there might be other legislative powers that could be vested, but at least these shall be herein granted.
Well, it actually, or maybe to parse that, I think that's right. So maybe to parse it this way, it's basically saying if Congress is going to have a legislative power, where does it have to come from? You want to answer that?
This document.
Yes, it's going to have to come from the Constitution itself. It's a power that's granted. All legislative powers herein granted shall be vested. So it's a grant of power. This document is granting powers to the legislative. We skip down here. The executive power shall be vested in a president of the United States. And anyone want to describe why that language, why this language of shall be vested, why that might say something very different now.
It's not as limited.
Because because that executive power is what I'll call downstream from the legislative work.
Yeah, or I think, and I think someone else also, I don't know who else in addition to Rob said, but it's basically saying, is the executive power granted by the document?
No.
No, the executive power seems to exist prior to and independent of the document.
Right.
So there seems to be this thing called executive power, which is vested in the president, but that exists prior to and independent of the document. Whereas legislative powers, if the Congress is to enjoy it, well, they have to be granted by the Constitution itself. And you might say, Okay, that's a very interesting semantic thing. What turns on that? And arguably a lot turns on it. And to give you an example of the kinds of things that turned on it, or I don't know, I can give you an example. Does anyone want to? Well, I'll throw out one thing and then we can maybe discuss it. So, for example, you might remember that right after 9/11, Congress issued something called the Authorization for the Use of Military Force. This was, I think, I think it might have been even something like September 17th, 2001. So really right after 9/11, Congress basically extended an authorization to the Bush administration saying that you can exercise whatever powers you need to exercise for the purposes of fighting Al-Qaeda and its allies. How did the Bush administration respond to that authorization of the use of military force? Well, they basically said, we don't need you to do that. We don't need this authorization from Congress because we already have this power. And it's a power that's already vested in us in the nature of the executive. We don't need to be limited we don't need to get this grant of power from you guys. We already have it. And these debates about whether this shall be vested kind of allows for a more expansive powers of the presidency, particularly in wartime, such that the Constitution itself is not understood as a restraint on executive powers in times of national security threat. That is a debate that continues to this day. So everyone kind of just with that, just trying to see the consequences of that. Here's the other, of course, the little bête noire of the Constitution that I think we would well, I'll argue that I would love to get rid of. And that is, just scrolling back a little earlier, that is, here's our little, here's our little electoral college stuff. The
Right there.
here's their electoral college disaster. Electoral college is a disaster. We can talk more about that. I think we can all be grateful that whatever we might think about the election of 2024, I think we can be grateful that that Trump won both the popular vote and the electoral college vote, because I think to the extent that he would have won the electoral college and lost the popular vote, like he did in 2016, would have again simply underscored the kind of the catastrophic ways in which we're tied to the caprices of this incredibly antiquated and arguably a dangerous system of electing a president. I'm looking at the time. I think I've already kept you for 4 minutes. I'm going to just mention a couple of other things that I would love to see changed. And here's one of them. Article 5. Article 5 of the Constitution tells us how you amend the Constitution. Now, one thing that's kind of interesting about the Article 5 of the Constitution, basically, if you look at it carefully, there are really 4 different methods. But the most common method is you get 2/3 of each House of Congress to support a constitutional amendment, and that can be ratified then by 3/4 of the states. That's the most common method of ratifying the Constitution, of amending the Constitution. If you actually look at the method of ratifying the Constitution, ratification of the Constitution requires 9 states. And the thing that's interesting about that is I already see Rob sort of smiling about that, because I think Rob is immediately recognizing that 9/13 is actually a smaller majority than 3/4. So it's actually easier to ratify the Constitution than it is to amend the Constitution. The other thing also to bear in mind is what I mentioned at the outset, which was the Articles of Confederation was actually the Constitution that was in place at the time. And the Articles of Confederation actually required unanimity in order to change the Constitution. And so what you have is a document that, in a sense, bootstrapped its own method of ratification. Because in a sense, this Article 7, there's a contradiction here because the Article 7 had no power until the Constitution itself was ratified. So how can the document itself articulate the process by which it would be ratified? Okay, and our last little thing, and again, when I say about Article 5, the reason I would like to change this, and I'm in good company on this one, because I think both, I mentioned at the beginning, Ruth Bader Ginsburg and her comments about the Constitution, both Ruth Bader Ginsburg and Scalia, who were very close friends, as you might know, Scalia and Ginsburg both agreed that if they could change something in the Constitution, one of the things they would change is Article 5. And they thought that because the Constitution is just too hard to amend. Our Constitution, constitutional scholars have made a study of this and have concluded that the American Constitution is probably the most difficult to amend of any constitution in the world today. And again, it's a little bit unfortunate, but very, very difficult to amend. And we see that given the very small number of amendments that we have. I mean, the amendments that we have are, think about it, we have only 27 amendments to the Constitution, but of those 27, really, we can boil it down to just 17, because the first 10 are the Bill of Rights, and the Bill of Rights were as we know, appended to the original Constitution to smooth the way to ratification. So we've really only had 17 amendments over 200 plus years of history. And of those 17, we really only have 15 because, of course, 2 of them are self-canceling, prohibition. And here's the last thing, again, something that might be controversial, but I'd get rid of this one, Second Amendment. If we were drafting a new Constitution, probably wouldn't draft a Second Amendment. And before we break out of this little session and field your questions or let you have, I'm going to quote in support of my unhappiness with the Second Amendment. I'm going to quote Warren Burger. Does everyone recall Warren Burger?
Yeah.
Warren Burger, Chief Justice of the U.S. Supreme Court, conservative Chief Justice, nominee of who nominated Warren Burger?
Richard Nixon.
Richard Nixon nominee. And this is what Warren Burger said about the proposition that the Second Amendment guaranteed an individual right to gun ownership. So this is a quote from Warren Burger. The idea that the Second Amendment confers an individual right of gun ownership has been the subject of one of the greatest pieces of fraud. I repeat the word fraud on the American public by special interest groups that I've ever seen in my lifetime. Very interesting that that comment was made in 1990s, and we know that in 2008, in the Heller decision, was the very first time that the Supreme Court actually recognized an individual right to gun ownership under the Second Amendment. And in fact, up until 2008, from 1791 until 2008, the total number of gun regulations that the Supreme Court had declared as unconstitutional was exactly, anyone want to guess the number that they'd struck down as unconstitutional between 1791 and 2008?
Zero.
Zero. None. All right, so I'm going to stop there. Paul, how did I do? So again, this is not meant to be, I don't want you all kind of then complaining to Michael Elliott about, oh, here we had this guy, all he did was disparage our fantastic Constitution. So no, I think there's a lot of actually obvious greatness to our founding document, but I do think that we have to recognize that there are defects that are very difficult to redress because of Article 5, because it's so difficult actually to amend the Constitution. Many things that I think we would probably get a consensus about to get rid of, such as the Electoral College. It's very hard to get rid of because it's anchored in the Constitution itself. In fact, it's very interesting. Paul knows all about this, but the very first effort to get rid of the Electoral College by constitutional amendment came in 1816. The first serious effort to get rid of the Electoral College. So anyway, so I'm happy to answer questions. I'm happy to let you all break off into your groups.
Lawrence, let's do this. Let's for 20 minutes break into our groups. Do you have you've posed a lot of challenges to the Constitution. Is there a question or two that you want the breakout groups to consider?
I mean, you could absolutely consider something along the lines of, now, obviously you don't have the document in front of you, but you could consider something like, if I could change something about the American constitutional democratic reality of today, what would that be? It could be something like amending the Constitution. It could be something about, I would love to deal with the problem of gerrymandering. I'd love to deal with the problem of, just something along those lines. Maybe that's a question that you can ask. You could ask, and you could, I suppose, ask, what do you think of my idea that we wouldn't want a Senate if we were, or something like a Senate if we were redrafting the Constitution of today, that we'd want to have a larger House of Representatives, that on some level the Constitution, unfortunately, works to create almost a system of minority rule rather than majority rule.
Yeah.
So I
good
think
questions. Why don't we go with let's start with those two. And when we come back, let's make it 20 minutes. Wendy's got the control. And when we come back, think about either sharing your perspectives on that or any other questions, for Lawrence in the final 20 minutes that we have together.
Yeah.
Welcome back. Did you get a few months? There you go. Glad you got something. Well, welcome back, everybody. I know in our group, we raised several important questions, and we sort of encouraged everyone to chat about them and to ask Lawrence directly. I will say one quick thing, and then I will just kind of open it up. And I think the best way to do this is if you can raise your hand, and there's a way to do that rather than just calling out, but I'll do my best to moderate this. I know, Lawrence, one of the several of the things we did in our group, and you may get some more questions, is to say a bit more about some of the applications or implications for the questions you raised in terms of the current election, and some of the challenges we're facing in the Trump administration. So that may come up. But let's just let me go. Bob Howard.
Yes. Can everybody hear me?
We'll go Bob, then we'll go Andrew Steinfeld. So Bob, go ahead.
Yeah. So Lawrence, a really interesting question came up in our working group, and it actually has a connection to Amherst history, which is the Noah Webster, one of the founders of the college, who basically had a view that within the Constitution and the promise of Republican government, there was a kind of anti-oligarchy impulse. In other words, you had to have a more or less equal condition among the populace in order to have a Republican government. So at a time when, Elon Musk, you name it, we're looking like we're moving toward a more, kind of hyper-rich oligarchy. Is there promise in the Constitution to combat that?
Yeah, I don't think first of all, the Constitution obviously doesn't say a whole lot about the the kind of the economic system of the United States. I mean, in many ways, the Article 1, Section 8 of the Constitution gave Congress certain powers. Powers to control the economy really weren't broadly recognized as powers that belonged to the Congress until late in the 1930s. As you probably know, the Supreme Court in the early decades of the 20th century really was an obstacle for aggressive intervention to alleviate some of the pains caused by a free market system. And one of the things that we've seen in this country, we have seen a very dramatic increase in wealth inequality from the 1960s until now. In the early part of the 20th century or the end of the 19th century, you saw very grave disparities in wealth among Americans. Those kind of decreased through the 1960s, and then they've increased very dramatically since then. I mean, one statistic that I shared with my class was about something else, but if you look at the average wage of a worker and compare that to CEO's salary, in about I think it was 68, it was 21 to 1 was the ratio of CEO's salary to average worker salary. Now it's about 360 to 1 in terms of CEO salary to average worker salary. So there has been this very dramatic concentration of wealth. And, some people talk about the top 1%. That's really a misleading statistic. It's really the top 1/10 of 1% or even 1/100th of 1%. And unfortunately, the Supreme Court in many ways has failed to permit legislative acts that were intended to correct some of that imbalance, or at least that the effect that imbalance would have on our political process. So many of you are probably familiar with the McCain-Feingold campaign finance law. And it was really a bipartisan piece of legislation. It was supported by both Democrats and Republicans. Remember, obviously, McCain is the Republican from Arizona. Feingold is the Democrat from Wisconsin. It was signed by President Bush, and it was declared unconstitutional by the United States Supreme Court in the Citizens United. At least parts of it were declared unconstitutional in this decision of Citizens United. And that really was meant to try to get a control over the amount of money that could flow into political campaigns. And the Supreme Court argued that that in restricting the amount that both for-profit and nonprofit corporations could spend on behalf of candidates, that this law essentially was violating the First Amendment rights of these organizations. And unfortunately, is there a plausible argument for it? Yeah, I suppose it's a plausible argument, but I think it was overlooking the real political reality that Congress, in an unusual demonstration of bipartisanship, was trying to address. So I think that was a very unfortunate decision, the consequences of which we continue to see today.
Got 3 questions waiting. Andrew Steinfeld first, then Charlie Bergman, and then Jordan Goodman. Go ahead, Andy.
Okay, thanks. Lawrence, I'm Andrew Steinfeld. I was a Foreign Service officer for almost 40 years. So my interests tend towards that. And I have a question about, you mentioned the AUMF. It's interesting that you raised that. But as I recall, and I just checked, it's up to Congress to declare war. And that hasn't been used in a long time. And I'm just wondering, if I look at how our presidents have done military activity, if I look at something more current, and what you pointed out about the language, the first sentence in Article 1 and the first sentence in Article 2, it was really interesting. And it seems to grant, some Trumpists might use that to say, look, we have unlimited power because it's not as elaborated herein. But so when it comes to declaring war, the fecklessness of the Congress. When Trump raises the notion of recess appointments at the beginning of a term, and the pushback should have been much more robust. Every senator should have said, fuck you, this is our prerogative according to the Constitution. But so my question to you is, over time, has Congress simply ceded power to the president by its own fecklessness?
Well, I think maybe there are two separate issues that you're raising. One is the certainly with respect to, I mean, the last war that we've had declared was the Second World War. That was the last war that was declared by Congress. Has the United States waged war since World War II? Obviously, the answer is yes. And so in many ways, that kind of the war powers that are vested in Congress, I think they have very significantly eroded. It's a very tricky thing because you can't necessarily think of I mean, there were efforts during the Vietnam War to bring suits before the Supreme Court, arguing that because this was an undeclared war, it was unconstitutional. And obviously, the Supreme Court is not about to intervene and pass judgment on the constitutionality of a conflict when you have 500,000 Americans already, let's say, deployed abroad. So they're not going to kind of touch that issue. They're going to kind of treat that as a political question that is basically given over to coordinate branches of government. And we can sort of understand why the courts would not intervene. But I think with regards to Congress has been a kind of a derogation of the responsibility with regards to war. Yes, there has been. It is a tricky kind of thing because you do want the executive to be able to respond aggressively and flexibly when confronted with national security challenges. But that said, you really had extreme things that during the George W. Bush administration, Bush 43, and the response to the War of Terror. I mean, some of you might be familiar with these so-called torture memos that were drafted by someone named John Yoo. John Yoo, who at the time was in the Office of the Legal Counsel of the Justice Department, is now a professor at the Berkeley Law School. And one of the things that you argued, which was really quite astonishing, was he said that the federal law against torture would be unconstitutional if applied as a restraint against executive action in a time of war. Really very, very kind of radical conception of executive power. The other point that you make is a little different than fecklessness, and that has to do with the way in which the GOP has, in many ways, become this kind of cult of personality, and that's a very different and also very dangerous trend that you have. You know, these really kind of heroic figures like Liz Cheney basically being completely exiled by the Republican Party, and the way in which the party has, rubber stamped Trump in ways that really go against the whole notion of check and balances. I mean, check and balances is really meant to be which one branch of government is exercising constitutional restraint on the other, and that doesn't work if one just kind of caves out of either a combination of cowardice or opportunism to the political will of someone who is running roughshod over constitutional norms.
Yeah. Charlie Bergman.
Thanks, Steve, and thank you, Lawrence, for joining us tonight. I'd like to ask a question that's just kind of a coda on what you just said a moment ago. First of all, I've enjoyed so much reading your op-eds at The Guardian.
Thank you.
I just want to quote the title from your December 2021 op-ed, quote, "Republicans are plotting to destroy democracy from within." Do you think that's true?
Well, the one thing I'll say is, much as I appreciate, Charlie, your reading of my my pieces, one author, this is the familiar punt of all commentary writers, is we do not write the titles. We have no control over the titles of our pieces. To the extent that I remember what I was writing there, I don't think I was, I don't believe that there's a conspiracy among members of the GOP to destroy American constitutional democracy. But I do think that they have failed in their responsibilities. I think a really dramatic failure, again, obviously just speaking for myself, is, I think it was a dramatic failure to fail to convict Trump in the second impeachment trial. I think that was really a very dramatic failure. I mean, recall they would have needed 67 votes in order to convict. They actually got 57 votes, so they get actually some GOP votes as well. But they were unable to get the basically supermajority that would have been necessary to convict. And I really do believe that if Mitch McConnell had put his institutional, kind of really put his weight behind it, they could have gotten those 67 votes. And I truly believe also that Mitch McConnell made a very dramatic miscalculation at that time. I think Mitch McConnell despises Trump. I think he would like to see Trump disappear from the scene. And I think he thought that he's already so discredited himself through the actions in his response to the insurrection of January 6th, that there's no way that he's going to remain politically relevant. And so just for the purposes of not trying to alienate other Republican voters, I'm not going to kind of push this. But I think that was a huge miscalculation on his part.
Yeah, thank you. Jordan Goodman, we're approaching 7:30. This may be our last question.
Okay.
Jordan, why don't you go ahead?
I was just wondering, what are you most worried about as far as Trump violating, as you would call it, constitutional norms? What on the Constitution keeps you up at night about that he could do that would be the worst in violating the Constitution?
Well, I guess, it's probably the same kind of thing that probably worries a number of you. I really do worry about what he can do with the Department of Justice. You use the Department of Justice as a tool for punishing your enemies and rewarding your friends. And that is, a real step towards eroding the rule of law in the United States. So that is one thing I really worry about, this overt politicization of the DOJ for partisan ends. I worry about who he will be nominating for federal court judgeships. Now, and again, I'm not even talking about the Supreme Court. I'm really talking about, remember, we're talking about, a full federal judiciary. And if you look at his last presidency, some of the judges that he nominated to the federal judiciary were certainly conservative, but also, very respectable and responsible jurists who actually voted against him in some of the challenges that he brought in the wake of his electoral defeat in 2020. On the other hand, you find some who are really kind of loyalists. And, people like this Aileen Cannon, who, as many of you know, was presiding over the documents case in Florida. And I worry about, the strength of institutions. Institutions are only as strong as the people who are occupying them. And if you're basically able to stack institutions with loyalists, you've taken a real step to turning the United States into kind of an illiberal democracy, in the model of, something like Viktor Orban's Hungary. Mm-hmm. And again, it's the Senate can place restraints on the president. The question is whether the GOP, again, has turned into such a cult of personality as to whether they're going to exercise the role that the Constitution has given them.
I think we've got Bob, is your hand up for a second question?
Yeah, I've got a kind of focused version of Jordan's question, which is, we're seeing a concerted attack on the institutions of higher education. Are you worried about Amherst in this environment?
So one of the things, I mean, again, I'm not exact. I mean, the attacks are coming from a lot of places. I mean, one thing to worry about, I suppose, is taxing our endowment. I mean, that would certainly be something that would be, I think, should be a source of our concern. And whatever other criticisms we have about higher education and elite institutions in the United States, it's something that functions pretty well. I mean, the elite educational institutions in the United States are many ways the kind of the jewel of higher education around the world. And if what you want to do is, kind of make the United States mediocre in all sorts of ways, one way to do it is to attack higher education. Just talking, and maybe this isn't directly germane to your question, I do think that there's stuff that also comes from the left within higher education that needs to be kind of walked back a bit. And I don't think he would necessarily use these words, but I do think that our present president is making a real concerted effort to make the college a place in which robust dialogue of different political views has a home. And I think that's a very important thing. I think in recent years, the matters that were up for open debate at a place like Amherst tended to be like that. And we want it to expand out. And just to give you a couple examples of this, some colleagues of mine, we recently brought in a couple of, conservative thinkers. We brought Ross Douthat, you might be familiar, the journalist of the Times, brought him in. I brought in Sir Neil Ferguson, a historian, very prominent conservative historian. And it seemed like the students, and a diverse body of students, really were they first of all, they showed up in numbers, and they seemed to be really grateful to have these different views being presented on campus. So I think that's, again, it wasn't directly germane to your question, but I think it was worth kind of bringing up just in terms of what we ourselves can do to kind of address some of the questions, some of the critiques from the outside, which I think are overblown, but are not completely made up without any basis in reality. Some of these critiques actually do describe things that need to be addressed.
So you're not worried of seeing on the federal level what we're seeing, say, in Florida?
Again, the federal government has very limited opportunities to control educational institutions. I think a lot can happen on a state level, but not that much can really happen on a federal level. I mean, the federal government obviously can do things. It can withdraw monies from certain schools. And again, this business about taxing endowments is a source of concern. But in terms of the capacity to have some kind of exercise control over the curricular offerings of a school, the content of the learning, federal government has a pretty restricted ability to do that.
Folks, I think we're going to have to leave it at that. Well, let me thank everyone, and a special Lawrence, thanks very much for your time and your expertise, your very good questions, and your critical analysis, something that we miss it. And finally, thanks for sort of bringing us back to an Amherst classroom.
Oh, yeah. Well, my pleasure. It's great seeing you all. Hope to do it again, and stay healthy, be well, have nice holidays.
Thank you. You as well. Nice to see everybody. We'll keep you posted about our next session. Take care. Happy holidays to all.
Thanks so
Take care.
much.
Okay. Bye-bye, everybody.
Bye.